Good morning to all esteemed members of the committee. My name is Nivin Sathyajith and I appear before you today as a representative of the Queensland Patients' Rights Association. We are here to speak on behalf of individuals and families across our state who have suffered preventable harm due to failures in the diagnostic process. Our submission will therefore focus on the critical area of medical negligence arising from misdiagnosis and delayed diagnosis, and specifically the urgent need for law reform to address cases where negligence deprives a patient of a chance of a better outcome. We thank you for the opportunity to present our arguments on this matter of significant public importance. I will now give the committee a brief introduction of what I will be speaking and addressing in my presentation. Firstly, we argue that diagnostic errors which reduce a patient's prospect of recovery should be recognised as a distinct and compensable harm. Too often, patients suffer irreversible consequences because of a condition that was not detected or treated in time. And yet the law fails to recognise the real value of the chances they have lost. Secondly, we highlight that the current legal framework, particularly under the Civil Liability Act, which I'll refer to as the CLA, and as interpreted by the High Court in Tabbitt v. Gett, creates a gap in accountability. Under this regime, unless a patient can prove causation on the balance of probabilities, they are left without redress, even where negligence is clear and the loss of a significant chance of recovery is obvious. Thirdly, we submit that our targeted statutory reform is required, specifically recognising loss of chance in defined contexts, recalibrating the peer professional opinion defence, and exploring hybrid no-fault pathways. These measures, we submit, would restore fairness for patients while at the same time maintaining safeguards against speculative or claims that have no merit. To guide the committee through our submissions, I will structure this presentation in 4 parts. Part 1 introduces the issues and its significance. Part 2 sets out the context and background of diagnostic negligence. Part 3 provides a summary and critique of the current law. And finally, Part 4 puts forward suggested reforms and a conclusion. In short, our central concern is that Queensland's current legal framework does not adequately reflect the realities of modern medicine, nor does it provide a fair and just outcome for patients harmed by diagnostic error. Reform is both necessary and achievable. Thank you. I will now move to a detailed examination of the context and background surrounding diagnostic negligence. It is essential to fully appreciate the scale of this issue, its human cost, and the legal foundations that currently govern it, as they set the stage for understanding why reform is so urgently needed. The prevalence and cost of diagnostics error. To truly grasp the significance of the issue, we must first confront the data, which reveals an alarming and systematic public health burden. The most recent national report from the Australian Commission on Safety and Quality in Healthcare provides a startling statistic. 1 in every 9 patients admitted to an Australian hospital will experience an incident linked to their clinical care. Now, within this broad category, diagnostics error, which encompasses both misdiagnosis and delayed diagnosis, is not a minor contributor. It is consistently identified as one of the leading causes of these adverse events. But what does this mean in practical terms? This isn't just about abstract medical mishaps. These errors directly lead to thousands of additional preventable hospitalizations each year. Each one of these represents a person whose condition deteriorated because the right answer wasn't found in time. The financial implication of this is staggering, running into the hundreds of millions of dollars annually in direct healthcare costs, a figure confirmed by the Australian Institute of Health and Welfare. This is a massive drain on our public health resources, funding that could be directed towards proactive care rather than rectifying preventable errors. Zooming in on Queensland, the picture does not improve. Queensland's health Queensland Health's own annual reports and adverse event statistics consistently highlights diagnostic error and delayed treatment as primary factors in serious patient harm within our state's hospitals. This is not an isolated problem or a series of unfortunate one-off events. The data shows it is a persistent and embedded challenge within our healthcare system. However, these numbers and dollar figures only tell part of the story. The true gravity is measured in human suffering. For an individual patient, a diagnostic failure is often life-altering, and tragically, life-ending event. Consider a patient with fast-growing cancer. A delay of even a few weeks in diagnosis can be the difference between a tumour being contained and operable and its metastasizing, becoming incurable. Similarly, every minute counts during a stroke. A delayed diagnosis directly translates to more brain cells dying, turning a potential recovery into a permanent, profound disability. The harm radiates outwards from the patient. Families are thrust into roles as full-time carers, facing immense emotional strain and psychological trauma. They often suffer significant loss of income, either from having to leave work to provide care or from the loss of the patient's income. The financial and emotional stability of an entire family unit can be destroyed by a single diagnostic error. Yet, here lies the cruel paradox. Despite the prevalence of this harm and its catastrophic effects, the pathway to justice is virtually closed. Data from the medical indemnity insurers themselves showing that only a tiny fraction of people who suffer this preventable harm even initiate a legal claim. And of those claims, or even a smaller number, ever proceed to a judgment in court. This enormous gap between the harm suffered and the legal claims made is the first and perhaps the most telling symptom of a legal system that is not functioning as it should. It is clear evidence of formidable barriers within the litigation process, barriers we will now explore. Duty of care and diagnosis. The legal obligation or duty of care owed by doctors to their patients is the fundamental principle that makes negligence claims possible. This duty is well established in common law and arises inherently from doctor-patient relationships. It encompasses three core aspects: the duty to diagnose with care, the duty to treat competently, and the duty to provide adequate information. The watershed moment in Australian law for this duty was the 1992 High Court case of Rogers v. Whittaker. This case was revolutionary because it firmly placed the patient's perspective at the centre of the legal test. The court held that a doctor must not only exercise reasonable skill and care in their examination and diagnosis, but must also disclose all material risks to the patients. A risk is considered material if a reasonable person in the patient's position will be likely to attach significance to it. This explicitly rejected the English Boland principle, which had allowed the medical profession to effectively set its own standard by deferring to responsible body of medical opinion. Rogers said the law, not doctors, would be the ultimate arbiter of the standard of care. That said, the boundaries of this duty are still sometimes tested. For instance, in cases like Harvey v. PD, the court grappled with whether a doctor's duty extends to third parties, such as family members or who may be at risk of communicable disease. While the core duty is solid, it edges in novel situations remain a subject of legal debate. Furthermore, it is critical to understand that this duty is not borne by individual doctors alone. Hospitals owe a non-delegable duty to their patients, a principle established in cases like Samos v. Repatriation Commission. This means a hospital is legally responsible for ensuring that reasonable care is taken in the diagnosis and treatment of patients within its walls, regardless of whether the staff are employees or independent contractors. Sanity care and statutory reform. Now, while Rogers v. Whittaker set a patient-centred common law standard, the legislative landscape shifted significantly in the early 2000s. Widespread concerns about so-called insurance crisis, rising public liability premiums, and the cost of claims led to the IPP report and the subsequent introduction of the Civil Liability Act in 2003 for Queensland, or the CLA. This act introduced a statutory modification to the standard of care. Most notably in Section 22, this section stipulates that a medical professional does not breach their duty of care if they can show that their conduct conformed to a practice widely accepted by a significant number of respected peer professionals as competent professional practice. In essence, this reintroduced a modified statutory version of the Boland principle that Rogers had rejected. There is a safety valve. The court can disregard a peer opinion if it is deemed irrational or unlawful. However, as the New South Wales Court of Appeal emphasised in Southwestern Sydney Local Health District v Gould, the threshold for finding an opinion irrational is exceptionally high. It is not enough for the court to simply think the practice is unwise or suboptimal. This creates a serious problem. It risks insulating negligent or outdated diagnostic practices from legal scrutiny simply because they are common enough to be considered widely accepted. A practice of systematic, under-investigated or overly conservative testing could be shielded even if it is demonstrably reduces a patient's safety. An important distinction must be made. Section 22 does not apply to the duty to warn. That duty is governed by Section 21 of the CLA, which effectively codifies the principles from Rogers v Whittaker. It creates both a proactive duty to provide information a reasonable patient would want and a reactive duty to answer specific questions. So while patient autonomy is preserved in the realm of informed consent, the actual act of diagnosis remains heavily protected by this shield of professional deference. Causation and the loss of a chance problem. This brings us to the single greatest hurdle for patients proving causation. Section 11 of the CLA codifies the traditional but-for test of causation. It requires a plaintiff to prove on the balance of probabilities, meaning more likely than not or greater than 50%, that the negligence was a necessary condition of the harm suffered. The devastating practical effect of this rule was set in stone by the High Court in the 2010 case of Tabbitt v. Gett. The case involved a young child who suffered brain damage. The evidence showed that the negligent delay in diagnosis had deprived her of a 40% chance of a better outcome. The court, in majority decision, held that this loss of chance was not in itself compensable form of harm, because the plaintiff could not prove that it was more probable than not, that is, over 50%, likely that the delay actually caused the brain damage itself. Her claim failed entirely in the eyes of the law that 40% chance had no value. This is all or nothing. Binary approach is fundamentally at odds with the reality of modern medicine. Clinical practice is inherently probabilistic. Doctors speak in terms of percentages and survival rates. Treatment decisions are based on statistical chances of success. A 40% chance is often considered a significant opportunity worth pursuing aggressively in clinical setting. Yet, in a legal setting, it is treated as worthless. The late Justice Kirby captured this perfectly in his commentary in Chappell v. Hart, where he described the burden of proving causation in medical negligence cases as Herculean for plaintiffs. How can a patient with scientific certainty reconstruct the alternative pathway their life would have taken without the negligence, given all the inherent uncertainties of disease progression and treatment outcomes? It is an immense and often impossible task. The result is a profound injustice. A patient can prove that a doctor was negligent, and they can prove that this negligence robbed them of a significant, quantifiable chance of a better outcome, yet they receive zero compensation. As scholars like Harold Luntz have argued, this outcome is a failure of corrective justice. It undermines public confidence that the legal system can provide a meaningful remedy for medical error and tells patients that even substantial lost chances have no value in law. This concludes the necessary context for our submission. We have a prevalent, costly, and a deeply human problem currently addressed by a legal framework that is ill-equipped to deal with probabilistic nature of medical science, leaving injured Queenslanders without recourse. I will now begin a comprehensive summary and critique of the current legal landscape. The first part will focus on two critical pillars of the system: the increasingly narrow duty of care and disclosure, and a formidable shield known as the peer professional opinion defence. It is crucial to the committee to understand that Queensland's medical negligence framework is not a pure common law system. It is a hybrid, a complex interplay of long-standing judge-made principles born from cases like Rogers v Whittaker and sweeping statutory modifications introduced by the Civil Liability Act in 2003. The stated policy goal of this hybrid model was to achieve a balance, to preserve patient access to justice whilst also protecting professional autonomy and ensuring the financial sustainability of our healthcare system. However, in practical application, particularly in the nuanced realm of diagnostic error, this balance has been lost. The framework has been widely criticised by academics and practitioners alike for erecting a series of daunting and often insurmountable barriers that disproportionately disadvantage the very patients who have suffered preventable harm. Duty of care and disclosure. Let's begin with the common law duty of care, the foundational ethical and legal compact between a doctor and their patient. This duty is well established and, in its general form, is not in dispute. The landmark 1992 High Court case of Rogers v Whittaker was a revolutionary moment in Australian medical law. It affirmed that a doctor's duty is profoundly twofold. First, there was a duty to diagnose and treat with reasonable skill and care. Secondly, and equally critical, is the duty to disclose. Doctors must warn patients of all material risk inherent in a procedure or, crucially for us, in a course of diagnostics or non-treatment. The genius of Rogers was its test for what is considered material. The court moved away from a professional-centric standard and firmly placed a reasonable patient at the heart of the inquiry. A risk is material if a reasonable person in the patient's particular position with their values, their concerns, and their life will be likely to attach significance to it. This was a powerful affirmation of patient autonomy, rejecting the Old English Bolam principle, which had allowed the medical profession to effectively set its own standards by deferring a responsible body of medical opinion. However, the practical power of this patient-centered principle has been significantly diluted by a more recent High Court decision in Wallace v Cam in 2013. In this case, the court performed a very precise, and for plaintiffs, a very limiting dissection of causation in failure to warn cases. The court clarified that proving a doctor was negligent in their duty to warn is only the first step. To actually succeed in a claim, a plaintiff must then prove a specific and narrow chain of causation. This involves two distinct hurdles. First, the subjective causation test. The plaintiff must prove that had they been given the warning that was so negligently omitted, they personally would have declined the procedure or chosen a different diagnostic path. They must convince the court of their own hypothetical decision. Second, and this is the more difficult hurdle, the materialization test. The plaintiff must prove that the precise risk that should have been disclosed but wasn't is the exact same risk that actually materialized and directly caused the harm they ultimately suffered. The harm must flow directly from the absence of information, not just from the underlying medical condition or a separate error. Let me give this a practical, real-world context for the committee. Consider a patient who presents with symptoms that could be indicative of a serious condition, like a deep vein thrombosis. A doctor might perform an examination, decide it's a muscle strain, and send the patient home without warning them of the small but yet real possibility of a clot, or a red flag symptom to watch for. This is a potential failure in both diagnosis and disclosure. Now, imagine that the patient later suffers a pulmonary embolism. Under Wallace v Cam, even if the patient can prove the doctor was negligent in failing to warn them of the risk of a clot, their claim can still fail, because they must also prove that the specific harm, which is the embolism, was caused by the failure to warn. If the harm is seen by the court as flowing from the misdiagnosis itself rather than directly from the lack of information, the claim will fail. The patient must prove that they had been warned. And if they had been warned, they would have gone to the emergency ward immediately, and this would have prevented the embolism. This is an immensely difficult evidentiary burden on the plaintiff. The most significant barrier is causation. Under Section 11 of the CLA, a plaintiff must prove that the negligence was more likely than not the cause of their harm. The High Court in Tabbitt v. Gett established that the loss of a chance of a better outcome is not in itself compensable damage. There, a 40% chance of avoiding brain damage was deemed to have no legal value because it fell below the 50% probability threshold. This creates an all-or-nothing approach that is fundamentally misaligned with the probabilistic nature of medicine, where even a substantial chance below 50% can be clinically significant. The result is that many patients who prove negligence and a significant loss chance are denied any remedy. Damages and statutory limitations. Even for successful claimants, the CLA imposes caps on damages. These statutory limits, designed for insurance stability, often result in compensation that is inadequate for patients with catastrophic injuries, failing to cover lifelong care needs. This prioritizes cost containment over full compensation and weakens the deterrent effect of the law. In conclusion, the cumulative effect of narrow duty rules, a deference to peer opinion, and the rejection of loss of chance and damages caps create a system that is systematically stacked against patients harmed by diagnostic error. This imbalance necessitates urgent reform. Having detailed the significant failings of the current system, I will now outline the Queensland Patients' Rights Association's 3 targeted, achievable and necessary reforms. These proposals are designed to restore fairness, accountability and compassion to a system that currently lacks all 3, while remaining mindful of the need to contain speculative litigation and control costs. First, we must recognise the loss of chance in law. The current law, as seen in Tabbitt v. Gett, treats a 40% loss of survival chances having zero value. This is unjust and ignores medical reality. We propose an amendment to the Civil Liability Act to allow for proportional recovery. If negligence reduces a patient's chance of recovery by a quantifiable percentage, damages would reflect that loss. A threshold, say 15%, open to negotiation, would prevent trivial claims. This aligns with models in Canada and the US, ensuring compensation reflects the actual harm suffered. Second, we need to recalibrate the peer professional opinion defence in Section 22. The current test, which only allows court to reject irrational opinions, sets the bar too high. We advocate adopting the Victorian model, which uses the more workable standard of unreasonable. This would allow courts to reject common but outdated or unsafe practices that do not meet contemporary patient safety standards. It restores necessary judicial oversight whilst respecting genuine clinical judgment. Finally, we urge the committee to explore the hybrid no-fault compensation model. A system like New Zealand's ACC, which provides compensation based on injury rather than fault, reduces litigation costs and promotes open disclosure. A Queensland hybrid model could offer scheduled, no-fault redress for specific diagnostic delays while preventing fault-based claims for egregious negligence. This balances timely compensation for patients with maintaining deterrence, and economic analysis suggests it could be cost neutral. These reforms, recognising loss of chance, calibrating Section 22, and investigating no-fault options, are necessary steps to create a system that is both fair for patients and sustainable for the future. In conclusion, the current law of medical negligence in Queensland systematically restricts and often denies recovery for patients harmed by the very system they trusted. Strict causation rules, as cemented in Tabbitt v. Gett, exclude all claims where negligence reduces the chance of recovery below the arbitrary 50% line. The peer professional opinion defence in Section 22 outsources the standard of care to the medical profession, protecting common practice over safe practice. And damages caps ensure that even successful claimants are often left with compensation that falls tragically short of their actual needs. Collectively, these measures prioritise stability and cost containment at the immense expense of fairness, accountability, and public trust. Targeted reform is both necessary and achievable. It is a matter of political will. Statutory recognition of loss of chance would align the law with medical reality. Recalibrating the peer defence would restore the primacy of patient safety. And exploring hybrid compensation would modernise our system for the 21st century. These reforms would better reflect the realities of probabilistic medicine, restore rights of patients, and maintain a sustainable balance between deterrence and affordability. This is not about blaming individual healthcare workers. It is about fixing a broken system. Queensland now has a profound opportunity to lead the nation by aligning its compensation framework with the principles of justice, transparency, and true patient-centred care. We urge the committee to endorse these reforms. Thank you very much for your time.